For delivery of judgment, WPC 6205/19.
Five points of determination. 5 points of determination arose in this case. First is whether the reference before the tribunal was sustainable, whether the tribunal could have disbelieved the evidence of birth certificate, whether the exhibited voters list could have been disbelieved because of age discrepancy, whether the petitioner, who is of Nepali or Gorkha origin, can be declared to be a foreigner from specified territory, whether the tribunal could have declared the petitioner to be a foreigner, though his projected mother was declared to be not a foreigner. All these issues have been discussed and decided. The reference is found to be sustainable because it was originated from the electoral registration officer. That aspect has been gone into. The age discrepancy was found to be of significance in this case because the names mismatched. Then whether petitioner who is of Nepali or Gorkha origin can be declared to be a foreigner despite Indira Nivar. We held it in the affirmative. The mother, in respect of the mother, she drew her lineage from her parents, whereas the petitioner would derive his citizenship through his father. Therefore, this was also affirmed. As far as the birth certificate is concerned, it was disbelieved because the order of the magistrate to extend the limitation, that was not brought. That was never the issue before the tribunal. It was no questions were asked. Therefore, on this point, we have remanded the matter, give an opportunity to the petitioner to bring the original records into it. But that was not the issue, and judicial and official acts are duly performed. Is something which is there under 114G. Therefore, it could not have been disposed on that. Some small corrections will continue.
Not permission to go through PCR of item 2 million. Maybe this is some other day million. Taken up some other
item number?
Item 2 million. Item 2.
2 is okay, 22. Okay.
I will go through the LCR to them, PCR to them.
Item 2. After yes,
grateful. Routine manner. Taking other development.
What is 2020? We are not obviously.
Yes, and second time,
the matter is
go through the records.
You go through it, but we are not adjourning any matter of 2020 and 21.
That is on any day.
No. You renew the prayer when the matter is called. Without looking at the records, you are not doing it. You know the position right now. The registry has informed us 2017 there are 3 matters pending. 2018, 85 matters. 2019, 515 matters. 2020, 189 matters. And 2021, 395 matters. When we will do it if we adjourn every matter like that? So till 2021, there is no adjournment. The mentioned time. Leave the prayer when the matter is called.
Maybe we'll have to go through the records.
May I please? With regard to item 17, my lord, I have taken consent from the other side, my lord. All the rest of them. Veterinary transport to them. Item 17 of hearing.
17.
17, 1 7.
I'm for the respondent number 1, 2, and 3, doctor.
I have also informed 5, 6, 7, 8, my lord.
You can say the appellant and the respondent numbers 1, 2, and 3 are represented. Next, the learned counsel for the appellant has submitted that with consent from the learned counsel for respondent numbers 5 to 8 is praying for an adjournment. There is a lot of matters adjourned today
After
to respond. Least after a week,
2 weeks.
2 weeks. Yes.
Deeply.
May it please your lordship, we have circulated an adjournment request with regard to item number 6, your lordship. There's some difficulty on our part, your lordship. We informed the counsel for the other side.
But 6 has been adjourned. This is a matter. It has been, it is here and every time. Like last time also it was adjourned. Why?
Lordship, today my senior has some difficulty, lordship.
I
Next week,
understand, but why every time the senior has difficulties? Last time also somebody took an adjournment in the matter.
lordship. So I apologize.
No. It is not appreciated. This cannot be appreciated. You take adjournment on the last one, and every time when it is listed, you have difficulties. You must adjust with the difficulties. This can't be permitted. How many adjournments have been given in this matter? And there is who is paying for the private respondents?
Lordship, we are there for respondent number 7, I believe, for the private.
Private respondent.
Lordship.
Now there is an order of this court of 13(5) asking you to clarify how the repetitions in the repetition number 17 of 2016 have acquired title.
Lordship.
It did not get any affidavit or anything on that. The query of the court.
So I apologize, but however, I do not have the instruction with regards to that, your lordship. So may it come up sometime next week, your lordship, Monday, Tuesday.
This is for the Union of India. You are there?
My son is called the appellant method.
On the prayer made by land council for the This contact number is 1 to 4. The matter stands adjourned today. Next, madam. Court takes notice of the fact that by an administrative order by the Honorable the Chief Justice William Beckett acting, dated 3/10/2018, this matter was taken up by the principal seat, as at that point of time the division bench was not sitting in Aizol. Which accordingly, the registry shall examine if the matter can be sent back to the Aizol bench for disposal. Next, for let this order be brought to the notice of the registrar within Beckett Judicial. Next, please. In the event the matter is retained in this principal seat, unless the matter for hearing on 8/9/2026. 8/9 sorry. September 2026. All sides are put to notice that in the event any prayer for adjournment is made on that date, the adjournment cost would be 25,000 for the said party. The court directs that the counterfeit copy of this order be sent by the learned counsel to the respective parties to put them to notice. Yes. Much more.
May please, your lordship, I'd like to mention item number 5, lordship, with the consent of the other side, lordship, I'm praying for adjournment, lordship, item number 5.
Okay. After 2 weeks.
Oblige, lord.
For motion, item 18, supplementary list.
May I please, your lordship. In this case, my lord, simple hearing was taken already by your lordship, my lord. But I am praying before your lordship, my lord, regarding the impugn order, my lord. If your lordship kindly consider, my lord, in the impugn order, my lord, regarding some of the exhibited documents and the deposition of the father of the proceeding, since the proceeding is a female, my lord, she had no, my lord, documentary evidence along with her father, my lord. The only linkage is the deposition of her father, my lord. And that was not at all considered, my lord. Nothing has been stated in the impugn order, my lord. whether it was discarded or it was appreciated by the learned member of the tribunal.
Father was DW3.
Yes, my lord, DW3 and brother is, my lord, DW2 only. Nothing has been stated in the imperial order. And regarding the linkage document of his father along with his grandfather, my lord, the only document is the land document, my lord, Jamandi copy, my lord. And that was straightway discarded, saying that this is a post-71 document. But by virtue of that document, my lord, the linkage is very clear, along with the, my lord, father and the grandfather. But unfortunately, my lord, the petitioner doesn't have any direct linkage along with her father as well as with her grandfather. That I admit.
Where is that Jamandi?
Yes, my lord. Take your lordship to, my lord, page 29, my lord, is the English, my lord, translated copy, and page 30 is the, my lord, vernacular, my lord. 30, my lord. Vernacular, page 30, my lord. The name of the father appears at serial number 3, my lord, Kasamali, my lord. Kasamali is the father of the proceedee and petitioner, my lord. And Kasamali's father is Sohar Ali. And this Sohar Ali is the grandfather of the petitioner, my lord. Now, if your lordship, my lord, kindly consider father and grandfather. And this father, Kasim Ali, my lord, he had come forward and he had deposed as DW3, my lord. That your lordship will find at page, my lord, 58, lecture 12, my lord.
Contention is that this land document creating the linkage between the father and the grandfather together with the deposition of the father constitutes the
Yes,
link evidence.
yes,
Petition.
my lord.
Yes, you want.
Yes, my lord, the deposition of the oral deposition of father is at page 58, my lord. Lecture 12, my lord, page 58, my lord. He is Kasim Ali, and he is the father of the, my lord, petitioner, my lord. He had deposed as DW3, my lord.
You see, the problem is elsewhere. The problem is that
My lord.
the father came and deposed.
Yes, my lord.
Now, he gave a oral statement that he has land documents. He
Yes.
has land.
Yes,
Which land he doesn't say. Number one. Second is that his own identity he does not prove. Now, the A comes and says that I am the father of B and therefore he is my son. That doesn't create an evidence either under section 50 or 112.
lord. He, since the only land document that was exhibited so far as this case is concerned, my lord, that is the Jamandi copy. And in that Jamandi copy, the name of, my lord, this Kasim Ali was reflected, my lord. And this Kasim Ali had came forward, my lord,
But
The
he
same
does not, in
person-
his evidence, he does not say that this Javamandi, this is my name.
He has said that we have land documents, that
Land document
implies
say-
that, that only land document, that was exhibited by the petitioner is the land document of him.
Just saying the right of,
And yes,
we don't know how many property you have. So if you say I have landed property, it can be, yes, you have landed property,
yes,
but which is the reference to the land property that you have not exhibited?
yes. But
How
I'm
do you
trying to
prove
submit,
that this land which is the Javamandi is there?
yes,
This land and the name entry is belong to him. How does that be ascertained?
my lord, since he said that he had a land document, my lord, and the only land document, that is the Jamabandi copy that was exhibited before the concerned tribunal, my lord. But so, my lord,
We see,
my lord,
we are dependent on the nature of evidence you are leading.
yes, my lord.
The problem lies there only. I have a land and this is my land. They are two different things.
Yes, my lord. I admit that, my lord, there is a technical difference, my lord. But so far as the land document of this case is concerned, my lord, the only land document that was exhibited, my lord, is the Jamabandi copy, my lord. Therefore, it clearly implies, my lord, so far as my humble understanding, my lord, this implies that this is the land document, my lord, which he had exhibited, my lord, before the concerned tribunal.
You once again look at that evidence at page 59. উভয়পক্ষে নথিপত্ৰ আদালতত দাখিল দিছে মোৰ নিজৰ মাটি বাৰী আছে আৰু মোৰ নাম ভোটাৰ তালিকাত
সন্নিবিষ্ট হৈ আছে। Next page.
নিশ্চয় হৈ আছে।
যদি মৰ্মুৰ ছোৱালীক ভাৰতীয় নাগৰিক হিচাপে বিকশিত কৰাটো বিচাৰে।
It is hard to presume that the land document which is so and so
Yes, my lord.
is this land.
He has said that, my lord, he has land documents, but yes, that I admit that he has not said that the Jamabandi copy that I have exhibited is my Jamabandi copy.
My name is.
He has not said, but otherwise, my lord, it clearly, my lord, implies that this is the, my lord, land document where, because of the name, my lord, similarity of name, reflection of name, my lord, it says that Jamabandi copy where the name of that Kasamali was reflected, my lord, serial number 3, my lord, is a Jamabandi copy of her father, my lord. Lordship will kindly consider that part, my lord. This is my humble prayer, my lord, before your lordship. If someone else, my lord, had come forward, my lord, other than this Kasamali, my lord, as DW3, my lord, I would not have made this prayer, my lord, before your lordship, my lord. Regarding his deposition, my lord, not a single word is discarded in the final opinion, my lord. Whether it is discarded or it is accepted, my lord.
Sharma. Please come to page 63.
Lordship, second from
Grandfather's deed.
The year 19.
Right,
75.
yes.
65 and 70. Where is that document?
70 is also there, 65 and 70.
have that. Those documents.
The only thing is that, my lord,
Which page are those documents?
the voter list, my
5
lord,
and 70.
70 voter list at page 22, my lord, Donna Close. Grandfather's voter list.
It's a small paragraph, but discussion was made, Lordship.
Regarding
It's a
the,
small paragraph, but discussion was made in respect of DW2 and DW3. From bottom, page 63 from bottom, Lordship, second paragraph.
Yes.
63.
oh,
I think, Lordship,
Yes, I've seen it.
no, it doesn't say anything, my lord, clearly, my lord. It doesn't say about the, my lord, deposition of the brother and the father also, my lord. Something should have been considered, my lord, by the panel member, my lord, the tribunal, my lord. If a lady, my lord, if she has no documentary evidence along with her father, my lord, she is helpless, my lord. She has to go by the oral deposition, my lord. And nothing has been discussed, my lord. There is no discussion, there is no finding, my lord.
How would I issue the certificate regarding our marriage?
Yes, yes, my lord. In fact, the school certificate is also there, my lord. And the school authority, my lord, the headmaster should have been, my lord, brought by the petitioner, my lord. He was not brought, my lord, ultimately, my lord. The school certificate is also there, my lord. Otherwise, my lord, had it been proved, my lord, the picture would have been more clear, my lord. Page 16 is the school certificate, my lord, annexure 1.
Mr. Sharma,
Yes, Lordship.
we are accepting the plea of Mr. Ahmad. We are sending it back for a fresh opinion with permitting him to call for the original land revenue records. You see here, come to page 20. This Zohar Ali is there,
Page Lordship.
2020.
This is total list, Lordship.
Yes. Zohar Ali, son of Ali Mahmud.
Yes, Lordship.
Now come to page 30. Here it is Zohar Ali Sheikh,
Yes.
but father's name is Ali Mahmud. The Sheikh word extra has come. How we dealt with in the written statement about that Sheikh?
And yes, Lordship, it's true, but Lordship, this is, I think, Lordship, not Kasam Ali, it is just like Kadam Ali, Lordship.
No,
This is, and Lordship, if he is actually Kasam Ali, then his name should be reflected along with his father, Lordship, in 1965, 1970, as well as 1985 totalists, because his name first time reflected at the age of 67 years, Lordship, in 2011 totalists, Lordship, page 26.
20?
In page 26. Yeah, whereas in evidence, Lordship, he says that, Lordship, my father died 8 years ago, Lordship. That is, Zohar Ali was very much alive up to 2010, Lordship. But after
Just a moment.
The first time in 2011.
yes, Lordship, at the age of 67 years, Lordship. Why his name was not reflected earlier, Lordship?
Just a moment. After page 30, what you are showing us?
Lordship, page 26 is the 2011 totalist, Lordship.
26.
2011 totalist. Kasam Ali's name appeared, Lordship, at the age of 67 years. So he is, if he is 67 years in the year of 2011, his name should be there in the voter list of 1965 as well as 1970, 1985, Lordship. So, Lordship, first of all, he has to prove that, Lordship, this Zohar Ali and that Zohar Ali, Zohar Ali is the same in one person, Lordship. It is his burden to prove that. Yes, Lordship. This Zohar Ali and
67 years. First time is very good.
yes, Lordship. Lordship. And I think, Lordship, tribunal is very precisely all the things has been discussed, Lordship. While O.P. Jahanara Begum herself failed to prove herself to be an Indian citizen.
Just a moment.
Yes, Lordship.
Where is the evidence of the father?
Father Lordship, DW3 page 59 Lordship, vernacular.
Not only expired, it was fine.
DW3, aged about 68 years.
Not this from his testimony.
In page 60 Lordship, is two court Lordship, because before the tribunal Lordship. Page 60, মোৰ দেউতাৰ নাম চহৰ আলী, মোৰ মাৰ নাম কয়ত বানু, মোৰ দেউতা ঢুকুৱা 8 বছৰ হ'ল আৰু মা ঢুকুৱাও 8 বছৰ হ'ল. And Lordship, although Kasam Ali's name is reflecting, my lord, in this Koyot Banu's name is nowhere reflected, Lordship.
Whose name?
Koyot Banu, Lordship.
His mother.
Yes, Lordship.
So you were questioning that whether it's true that the Sahar Ali,
Yes,
the father of Hassan.
yes, Lordship.
That is your
Yes,
this particular name of Sahar.
yes, Lordship. So if this Sohar Ali was alive up to Lordship 2010, then his name should be reflected in the earlier voter list after 1985. I think Lordship could not collect after 1985. Other voter list he could not able to collect this voter list, Lordship. Could not able to procure, Lordship, this voter list. Lordship. And I think, Lordship, nothing wrong has been done by the tribunal, Lordship, in this case, Lordship, because what tribunal has said, Lordship, page 63, while second last paragraph, Lordship, while O.P. Jahanara Begum herself has failed to prove herself to be an Indian citizen, in such a situation, the persons of DW2 and DW3 in favor of O.P.'s Indian citizenship are not believed to be true. And Lordship, if we see the WS Lordship, there is no pleadings at all, Lordship, in respect of his projected brother Lordship, whose name is Shahjahan Ali.
You're not following it. Please repeat again.
Lordship, regarding DW3, three evidence, Lordship,
Yes.
there is no specific pleading that
The father.
in DW2, in respect of DW2, Lordship, I am saying, Lordship, that Shahjahan Ali projected brother deposed before the tribunal, and there is no such pleading that Shahjahan Ali is the brother of the petitioner, as well as in his deposition projected father also not anything ventilated in respect of this Shahjahan Ali, Lordship. So this Shahjahan Ali's evidence also cannot be entertained, Lordship, in this case, Lordship. And Lordship, only link document has been placed by the proceeding this transfer certificate, Lordship. Which was, whereas Lordship, he left the school on 31/12/1997, whereas it is issued on Lordship 16/8/2018, Lordship.
Which page is that?
Page 16, Lordship. And Lordship, in this respect of this school certificate, Lordship, I want to rely 2018 3 GLT 347, Lordship.
Sudeja.
Yes, Lordship. Para 12. Exhibit A is a transfer certificate dated 9/1/2016 issued by the headmaster of Uttar Durabandhi Bill LP School certifying that Masammat Khudeja Khatun was the daughter of late Jonab Ali of Durabandhi Bill Village under Moirabari police station in the district of Morigao. She had left the school on 31/12/1988 after passing class 2. As per admission register, her date of birth was 12/1/1981. This certificate cannot be accepted as valid piece of evidence for more than one reason. Firstly, state emblem of India embossed at the certificate. The state emblem of India regulation of use rules 2007 has been framed by the central government in exercise of powers conferred by section 11 of the state emblem of India Prohibition Improper Use Act 2005. This act was enacted by the parliament to prohibit improper use of state emblem of India. Section 3 specifically prohibits improper use of state emblem. It says that notwithstanding anything contained in any other law, for the time being in force, no person shall use the emblem or any colorable imitation thereof in any manner which tends to create an impression that it relates to the government or that it is an official document of the central government or the state government without previous permission or authorization. Headmaster of the LP school is not authorized to use state emblem of India in any manner. Such unauthorized use of state emblem of India has rendered Exhibit A inadmissible in evidence. Secondly, as per this certificate, petitioner had left the school on 31/12/1988. This certificate was issued 28 years thereafter on 9/1/2016. Such belated issuance would necessarily cast serious aspersion on the bona fides of such certificate, which is highlighted by the unauthorized use of state emblem of India, that too not as per statutory format. Thirdly, and most importantly, the author of the said certificate did not appear before the tribunal along with the school admission register to prove the contents of the said certificate, more particularly date of birth and relation with late Jona Bali. How the date of birth in school certificate has to be proved has been settled by Supreme Court long back in Biratmal, Singhvi and Anandpur and so and so. So, Lordship, I think this paragraph is squarely applicable in respect of this case, Lordship.
What is the citation?
2018 3 GLT 347. Connected WBC number is 7756 2016.
Yes.
So, Lordship, apart from that, Lordship, on if this school certificate goes, Lordship, I think, Lordship, there is nothing will remain, Lordship, to prove his case that, Lordship, he is the son of daughter of Muhammad Qasim Ali. And apart from that, Lordship, oral evidence of father, Lordship, it is not enough. Already law has been settled in this regard, and Lordship, first of all, father has to prove that, Lordship, he is the citizen of India, Lordship. So in this case, he is not able to prove his case that he is this son of Sahar Ali, whose name reflected in the 1965 voter list, Lordship, or 1970. So, Lordship, oral evidence, in respect of oral evidence, Lordship, Noor Begum's case may be relied, Lordship.
May just put it, why the father has not been successful according to you? Because his name does not appear together. It's
Yes, yes, Lordship. His
only
name
at the
appears.
age of 67.
Apart from that, Lordship,
And
brother, projected brother,
Yeah,
if we calculate the age, Lordship, if we calculate the age, Lordship, projected brother's age, Lordship, page 56, he was aged about 22 years in the year of 2018. If he is 22 years in 2018, Lordship, he is sometimes born in the year of 1996, and his first voting right would be from 2014. Although this person, Kasam Ali, Lordship, appeared in the voter list of 2017 or 2014 voter list is not given here, Lordship, but his name was not reflected along with Kasam Ali, Lordship, his projected brother's name. So, Lordship, I think these all voters lists are procured by the proceeding from here and there, Lordship, and after that he trying to link herself with the person whose name reflected in the 1965 voter list, Lordship.
That is your point.
Evidentiary follow of oral testimony without support of documentary evidence is wholly insignificant. Lordship, regarding that, Lordship, law has already been settled, Lordship. I think nothing more to say in this regard.
So, suppose, how do we address that particular situation, which is projected by Mr. Jamal? That person got, a woman got married.
Lordship,
Woman got married
yes,
at a comparatively younger age. After my majority, but after comparatively younger age, she shifts. There is no document. Suppose that the woman gets married at 9 months, and then she shifts. She does not have any. By the time she attained the age of franchise, she was already married and shifted to the parental law. There is no voters list to her, but she gives a certificate from Gauhati. I mean, our law says that for shifting of married women, that is accepted. Right?
Yes, yes.
And then she gives a certificate from Gauhati regarding the marriage and shifting. And Gauhati also appears. Won't that be sufficient?
only for marriage purpose, Lordship, Gaon Panchat secretary can be relied, Lordship. And Gauhati certificate, Lordship, it was not proof at all, Lordship. Although here, Lordship, he placed one certificate in respect of Lordship, Gauhati, Lordship, it was not proof at all. Gauhati certificate is placed, it was exhibit position. Exhibit I, Lordship. It was exhibited as exhibit I, but this was not proof, Lordship. Not proof. So Gauhati has to
It was proof it could have been taken in that.
make if it is court may taken into consideration, Lordship.
Suppose that
If
circumstance,
it
by
was
the
proof.
by age of voting, she was not there in the case.
Actually, Lordship, actually, Gauhati is not authorized to issue such kind of certificate, Lordship.
But for shifting, our law says that it is accepted only for shifting of marriage. Right? I forgot to mention.
Yes, Lordship, regarding shifting, Lordship, Noor Begum has decided, Rupadan Begum, Lordship. In same case, Lordship, Khudeza Khatun's case, Lordship, yes, Lordship, in respect of Gaon Panchat secretary's certificate, Lordship, some observation has been made, Lordship. In para 15, Lordship, exhibit D is a certificate, that is Gaon Panchat certificate, then para 15 on 1, Lordship, from middle, Supreme Court has clarified in Rupadan Begum versus Union of India reported in 2018-1 STC 579 that such a certificate of Gaon Panchat secretary is by no means a proof of citizenship. Such a certificate has to be believed, verified at 2 stages. So, Lordship, this certificate was issued only in respect of married women, Lordship. No, yes, Lord.
Marriage and shifting.
Yes, Lord.
Not shifting,
But
standalone.
here, Lordship, no such certificate is here, Lordship. And Lordship, if we see the Gauhati certificate,
Just a moment. Yes.
Gaubra certificate is at page 18, Lordship. This is also not admissible document because state emblem was embossed at the top of the certificate. And Lordship, if certificate itself is not admissible, then question of proof it is not question of proving it is not arise, Lordship. And Lordship, here also Gaubrai not come before the tribunal to depose before the tribunal, Lordship. Only Gaubrai is certified that ইয়াৰ দ্বাৰা প্ৰমাণ পত্ৰ দিয়া হয় যে জাহানাৰা বেগম স্বামী শফিকুল ইছলাম মৈৰাবাৰী ডাকঘৰ চুৰেঞ্চো ওপৰত উল্লেখনে এই লাটৰ এলেকাধীনৰ অন্তৰ্গত বাসিন্দা হয়, বাট এই গাঁওবুঢ়া has not said that, Lordship, that particular person is the daughter of Kasam Ali, who is residing at so and so village, Lordship. It was not certified, Lordship. So after marriage, he come to that village, Lordship. That was also not here in the Gaubra certificate, Lordship. Lordship, my humble submission is that, Lordship, proceedings totally failed to establish his link with the projected parents, Lordship, or grandparents, Lordship. So opinion may not be disturbed, Lordship. And I think, Lordship, a learned tribunal has done nothing wrong, Lordship, in this case. And everything has been discussed, although no elaborate discussion is there, but everything has been discussed, Lordship.
Lord, I need to clarify certain things, my lord.
Yes.
There are some wrong submissions have been made before your lordship, my lord.
Yes.
Yes. First, I will refer to page 30 before your lordship, my lord. My learned friend has said that, my lord, the father of the name whom I have, my lord, according to him, I have projected as my father, my lord, is Kadam Ali, my lord. I'm very sure, my lord, he has said Kadam Ali, my lord. That's serial number 3, my lord.
Yes.
This page 30, my lord.
Yes.
This is a wrong submission altogether, my lord. Because, my lord, this was exhibited as exhibit F. Serial number 3. When I said, my lord, it is Kasum Ali, my lord. Now, if your lordship kindly turn to page 32, my lord. This has not been referred. That is also another exhibit, my lord, exhibit G, my lord. Land holding certificate. It bears the same dag number and same pata number. And the name is very clear, my lord. It is Muhammad Kasum Ali, my lord. Therefore, my lord, that submission is altogether a wrong submission, my lord. And this man, my lord, is the son of late Sohar Ali, my lord, whose name also appeared in the voter list of 1965. And that Sohar Ali is the father of Ali Mahmud. And that Ali Mahmud's name is also, my lord, reflected in the Jawandi copy, Ali Mahmud. And regarding the Sohar Ali Sheikh, my lord, at page 32, I'll take your lordship to at page 30 again, my lord. Mine. Lordship will kindly come to page 30 again, my lord. Yes. Now it is very clear that this person is Kasumali, not Kadamali, my lord. If it is compared to page 32, my lord, the land holding certificate, the dag number and pata number and the area remains same, my lord. Now Lordship kindly come to page 30 again, my lord. The Javamandi copy, my lord.
Yes.
The serial number 1, my lord, 1 Sohar Ali Sheikh, my lord. Here comes that Sheikh. And he was the son of Ali Mahmud. The name which appeared in the voter list of 1965, my lord. And if your lordship now again see that serial number 3, Kasum Ali, and below serial number 6, one Amir Jan, my lord. That just below that Sohar Ali is there, my lord, not Sheikh. It is again, my lord, in the correct manner, my lord.
Where? The left column only.
No, my lord, in the Potadaro Nam, Bapeko Nam, and Thogatha, in the same column, my lord, just below the serial number 6. There is no Sheikh, only Sohar Ali.
But his name here is mentioned as Kadaman.
Not Kodam Ali, my lord, Kasum Ali, my lord. He has, my lord, spelled out his Kadam Ali. Kasum Ali. And the member has not said anything, my lord. The learned member has not said anything, my lord, regarding that Kadam Ali or Kasum Ali. This is Kasum Ali. This will prove by the, my lord, this will be more clear if we go through the, my lord, by the, my lord, the land holding certificate. Kasum Ali.
So,
Oh, my lord, yes. This is very clear, my lord. And my lord, regarding my direct, my lord, linkage, as I have submitted before your lordship, my lord, there is no exact, my lord, direct documentary evidence. Yes, I exhibited 2 pieces of documents. One is the school transfer certificate of the petitioner herself, my lord. I'll take your lordship to that school transfer certificate again at page 16, my lord, 16. Here the name of the petitioner appears along with her father, my lord, that she is the daughter of Kasam Ali of the same area, that Ulubari, my lord, same village. Unfortunately, my lord, yes, it is the fault on my part that I could not bring the headmaster so as to prove the contents of that certificate. But it is also true, my lord, that this certificate was exhibited, my lord. Therefore, my lord, I was submitting on earlier, my lord, that I am not pressing on this documentary evidence, my lord. This lady is helpless otherwise, my lord, if your lordship doesn't consider the, my lord, the oral deposition. Now, why oral deposition is required to be, my lord, considered, my lord? I'll take your lordship to oral deposition of the father, not the brother, my lord. Since the brother's name, my lord, did not reflect in any of the document, my lord. Lordship will kindly come to page, my lord, 58 again, my lord. Why it is required, my lord? 59 is the, my lord, vernacular, and go by the, my lord, vernacular version, my lord. Is there anything, my lord, in the, my lord, impugn order, my lord, regarding the deposition part of the father? Now, this man has not come directly, my lord, that he, without having his name in any piece of document, my lord, this, someone came as Kasum Ali saying that this petitioner is my daughter, my lord. He has not said like that, my lord. Yes, there was a school transfer certificate that the contents was not proved, my lord. I understand that, my lord. But regarding the other documents, my lord, even if, my lord, the voter lists are discarded, my lord, if you go by the, my lord, the land documents, my lord, with all respect, my lord, this Kasum Ali's existence is there. Now, whether this lady is his daughter or not, that has not been examined by the concerned tribunal, my lord. I'm sorry to say, my lord.
But should be relevant.
Yes, it is absolutely relevant, my lord. This is cogent and reliable, my lord.
71, the voters list are recent.
Yes.
The other one, 60.
Yes. Now, if you go by the, my lord, the oral deposition. My lord, if I may read the, my lord, the deposition part of the father again, my lord, this will be very clear, my lord. In fact, I am relying on three decisions, my lord. If your lordship permit me, my lord, I may be allowed to produce, my lord. Yes, my lord. Definitely.
DW3 has just come and deposed. He has not proved his identity.
My lord,
DW3 just came and deposed. Who is he? We don't know.
my lord, his identity is there, my lord, in the by virtue of the, my lord, land documents and the voter list, my lord. Even the voter list are not considered even. If you go by the, my lord, land documents, my lord, his existence is there, his name, his identity, everything is there, my lord, on record, my lord. Well, there has to have something, my lord, in the impugn order, my lord. He has not said a single word, my lord. On what basis the version of the, my lord, this DW3, the father of the petitioner, has been discarded? Lordship will kindly have a look at the state of Rajasthan versus state of Srimati Kalki and another. This decision says, my lord, tells about the discrepancy in testimony of witness. And it also says, unless material creates doubt about credibility of witness, his evidence cannot be discarded, my lord. Lordship will kindly note down, my lord. State of Rajasthan
He
versus.
doesn't have to. This is a criminal proceeding.
I understand, my lord, but
It's
they are
a-
very relevant to this my case, my lord. Paragraph 5 and 6, my lord, second last paragraph, only, page, my lord.
Material discrepancy in the criminal proceeding is totally different.
Here, there is no discrepancy. Nothing has been stated, my lord. In fact, my lord, when the deposition, my lord, seems to be, my lord, cogent and reliable, my lord, there has to have some consideration, my lord. Where is the consideration, my lord? The learned member has not said anything, my lord, regarding the, my lord, deposition part or the cross part of the, my lord, father of the petitioner, my lord. And regarding the land documents, my lord,
That we have taken.
the learned member has said that these are post 71 documents, therefore these are discarded, my lord. Simply saying that, my lord. He cannot discard it, my lord, in such a manner, my lord. Another one is, my lord, Subodhnath, and another was the state of Tripura, my lord. The last one is, my lord,
Is this which paragraph we are going? Both not.
Subodhnath, yes, my lord. That paragraph 6 and 7, my lord. Be very clear. And in earlier case, my lord, that Kalki, my lord, state of Rajasthan, para 2 in the second page is also, my lord, relevant, my lord. Yes, 2, 6 and 7, my lord. Yes, my lord. And the last one is, my lord, state of Himachal Pradesh versus state of versus Mastram, my lord. This is very relevant, my lord. Para 11, my lord. Second last page, my lord. Third page, my lord. Third last page, my lord. Para 11, my lord. That, my lord, state of Himachal Pradesh versus Mastram, my lord. It says that the law on the point is well settled that the testimony of the relative witness cannot be disbelieved on the ground of relationship. The only main requirement is to examine their testimony with caution. Their testimony was thrown out at the threshold on the ground of animosity and relationship. This is not a requirement of law. The Supreme Court has clearly said, madam. Para 11 minutes. Therefore, my humble submission before your lordship, my lord, is that my lord, lordship will you please to my lord remand back this matter, since my lord the
How does this Subodhnath case help you? Paragraph two, 2, 6 and 7 you have read. What part of the paragraph helps you?
Subodhnath, my lord. This says about my lord, the discrepancies of evidence, my lord.
No, which part of this paragraph 2, 6 and 7 helps you? Please pinpoint that part of the paragraph.
My lord, in the second page in Subodhnath's case, my lord. Second page, para 6 and 7, my lord.
Please point out that part. You have read it twice.
My lord.
Which part actually helps you?
My lord. Para 13 is also relevant, my lord. 13, my lord. Once we find that the eyewitness account of PW 13 is corroborated, para 13, my lord, last page, my lord. Para 13, my lord.
It is different because of the facts of the case.
Yes, facts of the case, but merely saying that by having suspicion, my lord, the entire, my lord, the position cannot be discarded, my lord. Here in my case, my lord, nothing has been discussed, my lord, whether it is believable or disbelievable, according to the finding of the learned tribunal, my lord.
And this state of HP versus Mastram, which paragraph?
Yes, my lord. Paragraph number 11, my lord. Second last page. In paragraph 11, line 12, my lord. It says that the law on the point is well settled that the testimony of relative witnesses cannot be disbelieved on the ground of relationship. The only requirement is to examine their testimony with caution. In the given facts of the case, it is but quite natural that the relatives would have accompanied the deceased to collect the fodder of the cattle from the fields at about 10:30 a.m. On the fateful day. The fact is different, my lord, but it can't be, my lord, disbelieved, my lord, merely having the relationship, my lord, it says, my lord. But in my case, my lord, there is no disbelieving, there is no suspicion, there is no mentioning, my lord. Therefore, my lord, my humble prayer before your lordship is that lordship will be pleased to, my lord, remand back this matter, my lord, just to examine that part, whether this man, this DWT 3, my lord, who came forward and deposed and who was also cross-examined, was it believable or disbelievable? And is he the original biological father of the proceedee or a projected father, my lord? This has to have, my lord, there has to have some reason, my lord, in the final opinion, my lord. And this, since the petitioner is a lady, my lord, she doesn't have any, my lord, specific document other than the school certificate, my lord, along with her father. She can't produce any other documentary evidence, my lord, if it is sought even by the concerned tribunal, my lord. The only way that she will be able to, my lord, defend her case is to go through, my lord, by the production, my lord, go by the adducing of witnesses only, my lord. He has no option, my lord. That's why, my lord, I'm submitting before your lordship. Lordship will be pleased to, my lord, remand back this matter.
So
Just
that
to
the
examine
law
that
is
part.
well settled. So that the law is well settled.
Lordship, only small submission, Lordship.
Evidence for the purpose of proving citizenship has been well settled by this
So,
court.
my lord, the highest civil that a person concerned, my lord.
Lordship, page 30 again, I am relying. Page 30. Page 30. চিঠাৰ সহকাৰী বন্দোবস্তি প্ৰাধিকাৰীৰ 7/9/81 তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে এক নং স্থলত মিন্স চহৰ আলি লৰ্ডশ্বিপ 1 নং স্থলত so and so were including Kasamalis name was mutated, lordship. That part was there. If in his evidence, lordship, he has said that, lordship, his father Kasamalim, page 60, lordship, মোৰ দেউতাৰ নাম চহৰ আলি, মোৰ দেউতা ঢুকুৱা 8 বছৰ হ'ল. That means his father was alive up to 2010, lordship. So how he can get this land by way of inheritance, lordship?
These are technical aspects, my lord. These are very, my lord, these are
Their
illiterate
evidence,
person, my
Lordship,
lord.
they are saying,
They exactly
they are
cannot say, my
saying-
lord, when this father died, my lord.
page 60, Lordship.
51.
Lordship.
This the year does not tell you with this
Yes, Lordship.
question that it died 8 years back.
Lordship.
Okay, problem consider. Heard Mr. Z. Hamad, learned, heard Mr. Z. Hamad, learned counsel for the petitioner, and so for the respondents. So submissions are concluded, order reserved.
I'm deeply obliged, my lord. One more prayer, my lord, before your lordship, my lord. In item, my lord, 16, my lord, second last item in the hearing, my lord. There is a similar name, my lord. I have come with a different file. He is also further, my lord. I'm very sorry, my lord. Lordship will kindly pardon me, my lord. I have come with a different file, my lord. Lordship will fix it any day in the next week, my lord. Having similar name, my lord, my fault, my lord. I apologize for that, my lord.
You'll have to purchase this tag machines.
Sorry to say, my lord.
And take the records.
But since the name resembles the same, my lord, by mistakenly I have to come with the same name. file.
Which item?
Item 16, my lord. The last, my lord, here, second last hearing item. What says that presented on the fair made by and counsel to the petitioner, matters and judgment to the rest on due date after a week. I'm deeply obliged.
Supplementary item 19 for orders.
Lordship, may kindly take up IA 2567 first. Lordship, here, it is for implement of the finance department as a party respondent because they were, Lordship, party in the reproceeding, but inadvertently, it was dropped, in the read appeal that we have filed. I'm just praying for implement of the finance department as a party. Lordship, we will find in the judgment, Lordship, page 16, Lordship. Finance Department, Lordship. Respondent number 13.
One series, Mr. Aisha, he's always here. He's always here, I understand.
We allow the implement. We allow the prayer for implement.
There is a delay implement to IR. What's the delay?
Even in delay, this is required.
Implement I have no. But for the delay,
No, it's okay. Okay. Technically, you are right. because it can't affect the memo appeal right now. Okay. But whatever the delay, we'll take into that consideration. This will not be dismissed on that account.
Lordship, here we have preferred the writ appeal against judgment and order dated 19/10/2023. Lordship, where learned single judge directed for regularization of the petitioner who were already regularized as grade 4 master roll worker in grade 3 post in view of their long period of engagement in grade 3 post, and that too by creating a post. And while preferring this appeal, Lordship, there has been a delay of 679 days. And Lordship, we have stated the reasons in paragraph 4, 5, 6, and 7, Lordship. That is in page 7 onward.
Bureaucratic process.
Lordship.
Bureaucratic process.
Yes, Lordship, it's there.
There is the order of regularization dated 5/10/2005.
Lordship. Lordship, it will be at, Lordship will have to take up the memo of appeal, Lordship. It's there. Page 83. Lordship, here we have explained the delay. Lordship, may I read it, Lordship?
Yes.
Paragraph number 4 of the IA, Lordship. That on receipt of the certified copy on 8/12/2023, the Agriculture Department processed the matter in file number so and so, and the same was placed before the Joint Secretary Agriculture Department on 19/12/2023. Thereafter, the Joint Secretary Agriculture Department on 28/12/2003 directed for taking the views from Director of Agriculture Assam. Accordingly, the matter was processed and the draft letters were placed before the Joint Secretary on 8/1/2024, who in turn forwarded the same to the Additional Chief Secretary in charge of the department for necessary approval on the same day. That on 8/1/2024, the Additional Chief Secretary in charge of the department approved the proposal of the Joint Secretary and further directed for taking the views of the Judicial Department as well. Subsequent thereto, the draft letters addressed to the Director of Agriculture, Assam and Legal Remembrance and Secretary to the Government of Assam Judicial Department seeking their views on judgment was prepared and placed for consideration before the Joint Secretary on 11/1/2024 and the same were issued on 16/1/2024. Thereafter, as the Honorable Court has directed for giving all consequential benefit, including back wages, which has financial implication, it was decided to take the views of the Finance Department. Accordingly, on approval, the said letter was issued on 19/1/2024. In response to the letter dated 16/1/2024 seeking views of the Judicial Department, the Judicial Department on 5th February 2024 requested for some documents on the matter in order to give their views. Accordingly, the same was processed and issued on 22/2024. On 22/2024, the Agriculture Department received the views of the Finance Department suggesting for obtaining the views of Judicial Department and then submit a comprehensive proposal before the Finance Department for further consideration. On 28th February, the Agriculture Department received the views of the Director of Agriculture in response to the letter dated 16/1/2024. A decision was taken on 28/2/2024 to send a reminder letter to Judicial Department for an early response to the communication sent on 16/1/2024. Accordingly, a reminder letter dated 29/2/2024 was sent to the Judicial Department. The views of the Judicial Department were received on 7th March 2024, which conveyed the Agriculture Department to go for appeal against the judgment. Pursuant thereto, the same was submitted before the higher authority on 13/3/2024 for approval. On the same date, the Commissioner and Secretary concurred to the view of the Judicial Department that upon various deliberation and examination of the entire matter with the Standing Council, the applicant, while later dated 3rd September, requested the learned Advocate General Assam to prepare a writ appeal before this Honorable Court against the common.
There is a small problem here. The problem is that by this time, contempt case number 339 of 2024 has been filed.
Lordship.
So after that, the delay on this administrative side, we issuing letters, how does it help you? There's a recent judgment of the Supreme Court which has revived the earlier position that what was that, Postmaster General. That principles have been revived again. How do you overcome that judicial pronouncement?
Lordship, the recent judgment, Lordship, I have not read it reviving the Postmaster General case position.
No, that is there. What is the citation?
I'm relying on that. That is 2026 SCC online SC P level 2.
2026. The recent judgment.
SCC online SC P level 2. And relevant paragraphs are 27 to 42. where the Supreme Court has said, specifically in the context of contempt, that to overcome a contempt, you cannot file a report.
That will go heavily against you. Yes. Give it to him, the meantime, we take a 5 minute break and come back. We take a health break and come back.
Well,
Lordship, I have gone through the judgment just now. My learned senior friend has shown it to me. Lordship,
What's the name of the judge? Name of the judge.
this is
Israr
Israr Ahmed Khan versus
sir.
Amarnath Lopal.
Yes, sir.
Israr Ahmed Khan.
Israr, ISRAR. Yeah, correct. No, I will now remember it. We keep it because here it will again, there's a tendency to go here and there in the files. No, keep it. We'll take it. One copy. Just give one copy. My brother wants to.
Lordship, having both side view, Lordship, it completely goes against me.
Yes.
Lordship, let me go through it properly, Lordship. May take it up next Wednesday or Thursday, Lordship.
Next week again will be a difficult.
Next week, in fact, I am also continuously traveling all over.
Lordship, let it be in my Lordship convenience of my learned senior friend.
If you're not offended, maybe ask you which part of the globe.
No, within India. Delhi, perhaps Kohima, and then it out.
1st September.
3rd of September, sir.
First, I think is up to the third.
3rd September.
If it is not inconvenient, can it be fixed at 2 o'clock?
Make a mention in my policies. We don't want that time to be given.
Your Lordship, permits me just 1 minute. This is one of those cases. I'm sorry, my lord, I'm talking although you're not really deciding. This is one of those cases, my lord. Forgetting myself as a lawyer, even as a human being. But what has happened is these persons were engaged as private grade 3 employees, served for almost 2 decades. After that, regularized as grade 4 employees. Here is a case, my lord, where not only 14 and 16, even 21 right to live with dignity has been.
Somewhere we have found that the initial appointment was still under, still as a muster roll worker.
No, that is what is the documents will reveal that they were all along engaged as typists, extensions granted as typists. They were.
Was that because this is what we are missing.
There was what had happened. Then after regularization, they passed an order. Even that was under challenge. It was interfered with by the learned civil debt. They passed an order reverting them to, which itself is an admission of the fact that they were serving as grade 4.
Because this is something we are missing. We have.
But I will place the order, madam.
So grade 3. Initial appointment we found that it is muster roll worker. That's why.
No, that is where they.
Because we are sitting with a view that once they are muster roll worker, they could not have been regularized as grade 3 employee.
Yes. In fact, that writ petition has not been annexed at all.
Lordship, from page 71, and their initial appointment orders are there. Some of the petitioners.
This forms, there are three writ petitions. In fact, that is another technical objection we have. There were three writ petitions, and they have preferred a writ appeal in respect of only one. In the WPC number 7184, there is an order dated 13/11/2015.
This, insofar as WPC 4133,
One.
we find from page 32
One.
of the memo appeal, observation by this court, petitioners were qualified and were engaged temporarily, it is at page 32. Were engaged temporarily as typist grade 3 under the Directorate of Agriculture in the period of 88-90. Their engagements were extended from time to time.
One.
But this para 2 is again after anomalous regularization. This is something which we are missing from the appointment that they referred to at page 32 and 33.
In fact, my lord, if your lordship turns to page 33, Roman para 2.
That's why we are saying, you see, from para 1 to para 2, there's a missing link. Para 1 is, they were engaged as grade 3 post.
What?
Para 2 is after anomalous regularization. This regularization,
This is factually incorrect.
No.
No. That is why the learned English says, after such anomalous regularization, they continue to render services. The fact that they were in the meantime regularized,
that's missing
that
here.
link is missing. Otherwise, there are orders in the other writ petition. In fact, if your lordship so permits, since your lordship is posting it on, I think third, we can bring those documents on record. Against those writ petitions, they have not even preferred any writ appeal. There is an order dated 13/11/2015. After we filed the first writ petition, they passed an order reverting us back from grade 3 to grade 4. And that was after the regularization. That is an admission of the fact that we are serving as grade 3.
You keep it ready, don't file it.
But
Because once you file, it becomes a part of record. If they have not filed an appeal, why you want to bring it?
in fact, my lord, if your lordship just comes to page 85 of the memo of appeal 1.
85.
This again is an admission of the fact that they were all along serving as grade 3. This is after regularization. It is for information to all the master roll workers whose services have been regularized as grade 4 are to perform their duties in their respective places as were engaged prior to the regularization. This is a clear admission of the fact that we were all along serving as grade.
This is grade 4.
But regularized as grade 4. So after regularization, they realized the mistake and they continued to take our services in grade 3. What it says is this one. It is for information to all the master roll workers whose services have since been regularized as grade 4 are to perform their duties in their respective places as were engaged prior to the regulation.
Well, from
That is why the learned English says that it is an anomalous regulation.
let us see, from middle we can't understand anything,
Well,
but this.
We can place those documents. And otherwise also, my lord, there is another aspect. If your lordship just makes a note of these dates, the judgment is dated 19/10/23. We filed the contempt on, because the direction was to comply within a period of 6 months. After expiry of the 6 months, on 21/6/2024, we filed the contempt. They filed the writ appeal on even 7 months thereafter, 6/1/2026. And that writ appeal was not accompanied by a delay condemnation application, which was filed another 3 months later. In March 2026, the application for condemnation of delay. And in the meantime, what has happened is some people have retired. Very unfortunate state of affairs. Your lordships, as well as the Supreme Court, has time and again said that right to live with dignity is an important facet of Article 2. Just imagine the situation, all along serving as grade 3 and suddenly. In any case, will on third panel will keep those documents also ready, since those against those requisitions, no writ appeal has been filed. I mean, at least. Because the cause title says against all three.
What is the agreed date?
Third of September.
3rd of September. Mr. B. Chaudhary, Learned Counsel, Learned Government Advocate prays for an adjournment. First one, Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. N.J. Khatungya, and counsel for the respondents. Submits that there are some urgency, there is urgency in the matter, as many of the respondents have superannuated in the meantime. Huh?
There were
Okay,
14 originally. Three of them.
okay, few of them. He has also submitted that he has filed an affidavit in opposition in the matter. Full stop. Next panel. The learned government advocate has also submitted that that by filing a separate interlocutory application, which is IS Civil 2567 of 2026, impediment of the finance department has been prayed for, as the said party, was the respondent number 3 in the connected writ petition, was inadvertently left out. And the impediment is sought for as respondent number 13 in the connected memo of appeal. This is yet to be numbered. Next paragraph. The not that plus same paragraph. Instead, submission has been noted. Next paragraph. As agreed to by both sides, list the matter on 3/9/2026. One.
Daily list item 1 for admission.
Chief, kindly pass over the matter for time being.
One.
May please, your lordship. My lord, here in this case, the Incun opinion is at page 62. My lord, according to me, my lord, this is one of the badly conducted cases. But I'm searching and pursuing for justice from the available materials on record. Here in this case, my lord, this the petitioner has exhibited the 70 brutalist, 1970 brutalist, Annexer 3, page 29. Father's name Shivaruddin. Biological mother here recorded as Azimon Bibi, but correct name is Aziron Nessa, reflected in the subsequent brutalist. Azimon Bibi, but 89 brutalist recorded her name as Aziron Nessa Beva. And mother was also facing a proceeding, my lord. And mother was declared not for annulment.
Which page is the written statement?
My lord, written statement lordship will find at page 26.
26.
26, no. Annexer 2, page 26. The para 2 goes to show that is I'm not going at all. I'm in very good place. I'm in a very good place. Huh? Hmm? Medium? One eye. મારું નામ શું ગમ્યું છે ભાઈ কিন্তু brutalist 70 brutalist এটা দিছে মানে মাথা জানলে ডিসকাস করছি 70 brutalist My lord. My lord, if your lordship go through the WS, my lord, the pleading is very weak, my lord, not properly disclose the entire materials. But the documents of 1970 brutalist, which is relied upon by the petitioner, was also discussed in the judgment of her mother, my lord. My lord, my limited query is that since mother is declared not foreigner, so my lord, matter may be.
No, but you'll have to overcome the law laid down that the mother would get her citizenship claiming through her parents. Whereas the petitioner, she will draw the lineage from her parents. So therefore-
Mother was voter of 1970. Yes. And since mother was voter 1970, so my lord, if his mother, then my lord, how the petitioner can be declared foreigner, my lord?
Okay.
Mother is voter 1970. That has been discussed, my lord. 1970. 766. In 66 voter list NRC also, father's name is there, but 66 voter list not produced by the petitioner in her case. But 70 voter list also produced by the mother, and mother's name is there, and petitioner also relied upon that. So my humble prayer is that let the matter be remanded back, and if Aziron Nasa is mother, is found to be mother, my lord, in that case, my lord, petitioner may be
Please-
considered
please
as
take
not
us through the documents.
my lord,
Please take us through the documents, then.
my lord, my lord. My lord, voter list of 1970 at page, translated to be at page 29. Vernacular at page 1970. Father's name is Shivardin Akon. Here mother's name is wrongly written as Aziman Bibi, but Aziron Nasa or Aziman Nasa Beva is the correct name.
This
Aziron
is
Beva.
this is
Aziron Nasa
exhibit
Beva.
A.
That has been, my lord, in the voter list of 1989 at page 70.
Sibaruddin Okondo.
Petitioner was married
This Sibaruddin Akan is father,
father.
and Sohail Bibi,
His stepmother.
okay.
Then, my lord, her name appeared in the voter list of 1989 with her husband at page 33, 34. Again, my lord, 2012 voter list at page 35.
Now, this page 32 is 97.
Well,
After 1970, there is 97.
Right.
There's in between, there is no voter list.
no, my lord, not produced, my lord. exhibited as per the
This is exhibit B.
by
1997 is exhibit number.
1997. Exhibit A is the 1970 voter list. Exhibit B is the photocopy of 1965 voter list in respect of her parent-in-law. Exhibit C is the photocopy of 1997 voter list. Exhibit D Exhibit E is the certificate of Gauhati. Exhibit F is
Just first serially this document. Exhibit B, where is it?
Exhibit D is, according to the husband, no exhibit, but Exhibit D. No Exhibit D.
Exhibit B.
Yes, my lord, no Exhibit D. As per the judgment, my lord. Exhibit C is the photocopy, certified copy of 1997 voter list. Exhibit 97 voter list, what you will find at page 31.
The exhibit B is there.
My lord, the judgment says there is no exhibit as Exhibit D. There is one note in
Which page?
my lord, in the judgment it recorded.
Which page?
Page 63, my lord. Page 63, last but one paragraph, all the exhibits are discussed, my lord, mentioned.
Exhibit A is a photocopy of so and so. Exhibit B is a photocopy or certificate copy of so and so. It is mentioned.
Exhibit D.
No, we are in D. We are going serially.
Yes, my lord.
B is
Exhibit C.
65.
Photocopy of 1997 voter list.
Which page is that?
My lord, I am reading, my lord, page 63. My lord,
No, show us the exhibit serially. We have seen exhibit A. Now show us exhibit B.
C, lordship will find at page 32.
Exhibit B. No. That is 1997.
Exhibit D.
Show us serially.
Exhibit D, এত আমার নাম্বার তেনেকে এইবিলাকত মাৰ্ক নাই ন তেনেকে কম list 2012. Exhibit A is the voter list of 1970 in respect of parents. Exhibit B is the certificate of voter list of 1965, which are released to her parent-in-law, not of her own father. Then Exhibit C is the voter list of 1997, that is also released to her parent-in-law. Then 89 voter list is my lord, of her own. Then 2012 voter list, Exhibit E. So Exhibit D, here in judgment it is reflected that no Exhibit D, but Exhibit D is there 89 voter list.
Yes, please continue.
My lord. My lord, may I read the judgment, my lord?
So don't you just tell us?
My lord,
We have seen that by and large.
No.
The cooperative part of the.
my lord, here, my lord, the
Before,
petitioners claim that Hazirul Nessa mother is disbelieved by the tribunal because the sister, who is also a step sister, the step sister deposed that Hazirul Nessa is the stepmother. Admittedly, Hazirul Nessa is the stepmother for the DW2, not for the petitioner.
no, not only that, but she, DW2 who came, she does not even know the names of the children of her sister.
My lord,
That makes it very strange. In a lighter note, Mr. Siddhar,
my
in
lord,
a lighter note, not to be trolled for that, had I done that, I would have been murdered long back. Forget the name of the children of my wife's sister. I would have been murdered long back.
my lord, this illiterate lady, my
Not
lord,
that I'm
but
saying
he
in a-
mentioned the
I'm-
2 sons and 4 daughters, but name could not be mentioned.
I'm saying it a lighter note. I'm not commenting on your evidence at all.
But tribunal also hold that why not voter list in between 70 to 89. And the voter list are there, but not produced. The 75 voter list, Lord, you will find at page 67. Here, father's name recorded as Sibaruddin Akon, stepmother Shahid Bibi, full mother Aziman Bibi, Somiran Nasa, the husband, Somiran Nasa is the sister, step sister, Fazar Ali is her husband. Then 89 voter list, here mother's name recorded as Aziran Nasa Bewa.
The Gambura was not examined.
Not examined.
You are right. This case was not well conducted.
Well,
You are right.
Malad, documents, Malad, 1970 brutalist has been discussed in the judgment of her mother.
Just complete. You may make your submissions. I am looking at the records.
Malad,
My-
Malad.
You can continue with your submissions. Huh?
Yes, Malad.
That was it exhibit? It was not exhibit during the proceeding.
The tribunal mother judgment, not executed.
It's available in the writ petition.
Malad, I have annexed in the writ petition annexer 18. Father's name is discussed.
By the same tribunal.
Malad.
Same tribunal,
My lord, it is
probably different.
Forfeta, tribunal Forfeta,
Another
but
number.
the impugned judgment is of is in judgment, yes, my lord, of Forfeta, Forfeta. No, foreigners tribunal, I am reading your word. 94. Yeah. Foreigners tribunal was also there, simultaneous proceeding, both under Foreigners Act and the foreigner tribunal. Foreigners tribunal.
Who is Samiran?
My lord. Samiran, my lord, is the stepsister.
Who adduced evidence?
Yes, my lord, as a DW2. Her name is also enlisted with father in 75 brutalist, along with her husband and parents. He has deposed clearly that my mother's name is Shahiran Bibi. That means stepmother of the present petitioner. So automatically, my lord, Aziran Bibi will be our stepmother, and tribunal has picked up that proceeding claiming Aziran Bibi is mother, but Samiran is saying that Aziran is stepmother. That's the wrong finding, my lord. Yes, ma'am. Yes, madam. Yes, madam. My lord, I want to rely on the judgment of one Moharuddin Ali. Where this court has, there are some other judgment also. If one is declared foreigner, siblings will not go automatically foreigner. But I am relying on the Moharuddin Ali case, my lord. Here paragraph 8, 11, 12 and 16. 16 is the most relevant. There may be shortcoming evidence in one of the family members for which he is declared foreigner.
Is the evidence of DW2 annexed here? No.
DW2, yes, my lord, and annexed in page 59 in lead petition, my lord. NSR 14. Lordship got it. Page 59, translated copy. Original copy at page 60. I have come to have
This, just a moment. Who is this? Sohitan,
Somiran Nessa.
no, who is Sahitan Nessa?
Somiran Nessa. Somiran Nessa.
Sahitan, 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 who is he? You see, in our evidence, we are asking you to read it because in our deposition, that is at page.
My lord, DW2.
Yes, you will find this DW2 at page 59.
59,
which you are
yes,
showing.
madam. There, the recording is like
She
that.
says, OP, the name of my husband is, sorry,
Naively.
no. In the middle, I do not know the husband name of Sahitan Nessa. Now, where is this Sahitan Nessa come from?
Yes, I do not know the husband name of Shaitan Nessa. Well, I don't know why this line has come, my lord. Shaitan Nessa is not the proceeding. Yes, there may be some time mistake, no? Yes, Shaitan Nessa. Name of, I do not know the husband's name of Shaitan Nessa. Mistake may be from any side. The proceeding may say also, the witness may say wrong, tribunal may also wrongly written. So, my lord, this may be ignored, my lord, this line. My mother's name is wrong. But this part is important. Ajiran Bibi is my stepmother.
No, there is a reason why we are not discarding it. Please come to the voters list of 1965.
1965, that is voter list of,
Whatever,
yes, my lord. Naivali.
Sahitan Nessa is there. You see, the relevance is that this Akash is your grandfather.
Yes.
And she does not know the name of the grandfather.
My lord. Akel Ali is the parental. And parent-in-law, parent-in-law side.
Right. That is the grandmother of the DW2.
Parent-in-law of the proceeding.
And
Parent and Somiran Nasa is her sister.
sister is not a part
So
of the family. Okay.
sister may not know the and my lord, sister's parent-in-law, my lord.
Stepsister.
Huh? No. Akel. Somiran is not the proceeding. Somiran is the sister of the proceeding. And Akel Mullah is the Akel Mullah Sohitan Nasa, they are the parent-in-law. My lord, the DW2 has rightly said that the father-in-law of the OP is Akel Mullah. My lord, but unable to say who is the husband of Sohitan Nasa. Akel Mullah is the husband of Sohitan Nasa. My lord, my lord, a woman of remote village, and there is a practice in the Mohammedan family, in the particularly in the remote area, the backward family. They normally not discuss about the name of woman. So, but father-in-law name has been mentioned. So, my lord, this
No, you
mistake
see,
may be.
in a rural area, I have stayed in rural areas. The ladies will know everything. They would even know that in this household today, how many buckets of water has gone from the pond. They keep even that calculation.
My lord, this type of mistake
Perhaps
should not be fatal, but because husband's name, Akkal Mullah is the name of father-in-law, that has been clearly mentioned. So, my lord, this type of omission and commission should not be.
no, we are not formulating, we are not saying that we have formed an opinion, but it's very strange. At least not in any of the Assam village. The women folk will not know what is happening in the village.
My lord, these people, this type of people, when they appear before the court, my lord, they also sometimes confused. My lord, the father-in-law's name, father-in-law of sister has been mentioned clearly.
That means that this line is about it is both Not kidding.
That's some experience of them. The tribunal has discarded the evidence of DW2, saying that the proceeding claim Azirannasa baby is her mother, but Sabina, the sister, says that is stepmother. But in fact, the
Taking notes is
is mother.
told you.
Mother. My lord, the next point is my lord, that the father voter list of 1970 has been exhibited, and both the petitioner and his sister claimed that Sivaruddin upon this is their father, voter in 1970. That evidence has not been denied either by denial cross-examination nor any rebuttal evidence has been adduced. And the other point is, my lord, the mother declared not foreigner by another proceeding. And in that case, my lord, we are relying on some judgment, my lord. This, my lord, to ascertain whether that proceeding is her mother or not. If mother, my lord, then petitioner cannot be declared foreigner. In the light of this judgment in Moharuddin Ali versus Union of India, WPC 3128-17.
Please give the name again.
My lord,
For
Moharuddin Ali, I have the copy, my lord, I can start.
We have it.
My lord. Huh? WBC number 3128-2017. Moharuddin Ali, I have, my lord, copy has been provided, given, my lord. Paragraph 8, 11, 12 and 16, mostly, my lord, 16 is the relevant. In this paragraph 16, it has been discussed that in one case where negative order has been passed, maybe because of documents were not sufficiently produced. So that part is to be considered.
Paragraph 16.
My lord.
Paragraph 16.
16, my lord.
But this would be contrary to the Supreme Court judgment. This finding at paragraph 16 would be contrary to the Supreme Court judgment. You see, A and B are brothers. A comes into India in, say, 1960. B is the brother who comes into India after 1971. This principle cannot be applied
My
at
lord,
once.
that question is not here, my lord. My lord, here, my lord, mother declared not foreigner. So when mother declared not foreigner, how children can be foreigner?
No, we don't know. We're just asking you,
And in the judgment, in the mother judgment, discuss the same documents, my lord, in the, which is,
where is that, opinion of the mother,
my lord,
age?
my lord, the judgment is at page 71. NRC 5166 was produced in the case of mother, but not in the present petitioner's case, but 70 voter list. 70 voter list of voter list was produced in the mother's case as well as in the petitioner's case.
Yes, which part is favorable to you?
My lord, page 72, Lordship may look into the middle part of this paragraph, first paragraph. Opposite party has also produced the copy of voter list of 1970 at village Domini, where OP's name has been recorded as a voter along with her husband, Mohammed Sibaruddin.
Where is that document?
My lord,
1970?
70 voter list, my lord, in page 29. Village Domini. Father's name Sibaruddin Akal. But the name discrepancy has been discussed in the previous paragraph. Page 71. There is father's name discrepancy. The tribunal has discussed and ignored the name discrepancy.
So, as per this opinion at page 71,
My lord.
the reliance was basically on two, three things. That is the NRC of 51,
My lord.
that
NRC,
51 NRC is not there in this,
present case, 51 NRC was
not there.
66 voter is also not given.
66 is also not there.
Only 70 voters have been.
70 voter list. 70 voter list.
Of same village,
Mr. Siddhar,
my lord.
since you are referring to this page 71, we propose to give you an opportunity to satisfy us, because you see, in this, going by your submission, had you not started with the statement that it was not well conducted, we would not have given you this opportunity. But please come to page 30. We'll show you why we are not satisfied. Page 30, the voter list is Ajimon PV.
My lord.
Now please come to page 72, which is your type copy.
Yes, my lord. Aziron Nessa.
Yes. So therefore, this could have been ground to disbelieve you, but when you started with saying that it was not well conducted, we think we want to give you an opportunity to bring anything you can to supplement it. Otherwise, we are not satisfied.
Names are different.
My lord.
Photos name,
Here,
Abhimon BB.
Aziron, my
So
lord,
from this opinion itself, we express our dissatisfaction, but when you started with that note, we think we want to give you an opportunity to bring anything on record, either from the that tribunal certified copy or something of the evidence. When you can get a copy of this, you know where the record is, you can get a copy. Because since it is not an exhibited document, we don't want to pass an order to call for the records.
My lord, the
We have both,
lordship may also call for the record of the.
we are not calling that record.
My lord.
Since it's not an executed document, we don't want to create a precedence where we ask for documents which are not a part of
My lord,
the proceeding.
my lord.
But since you started with that note, we both are of the view that we
Right.
give you an opportunity.
Right.
Nothing more. Both sides are represented. On the prayer made by Mr. A.R. Sindhil and counsel for the petitioner, the matter stands adjourned today. List again on after 4 weeks.
After 4 weeks.
Your date after 4 weeks.
এই যে মাপৰ যিটো কেছৰ সেই তাৰ এক্সিকিউট বিলাক প্লিডিং বিলাক আৰু নতুন আৰু দুটা মেটাৰ নতুন My lord, I have some other matters, other 2 matters. Today maybe item 3, I think, no? 3 and 4, my lord. Any other day, my lord? The 3, my lord. 3 and 4 also, lordship may take up 3.
Petitioner, the matter stands adjourned today. List of your date after a week. After a week.
My lord, very good program now. Yes, my lord, after week. Here, my lord, in 3 cases, my lord, linkage is well established. My lord, there is a down on the copy. Only because of some minor, my lord, picking up some mistake in the Latmondal was examined. He said that we produced the original copy
There is some little variation with the certified copy with the record. That was the point taken up and to discard the on the copy. Four also, ma'am.
She's recorded with them.
44.
Item 7. Item 7.
One of the councils on record has expired. It seems. Other one is there. The council was on record.
In which matter there was an observation that one can come enter into India early and one at later point of time, siblings, throughout the system. In Supreme Court, there is a judgment where there's been referred that one sibling and one person can come. It's Abdul Qudus, right?
Principle of res judicata is not applied to separate proceedings even if against two closely related but different persons.
None appears in call for the petitioner. All the respondents are represented. The petitioner remained unpresented when the matter was previously called on 28/7/2026. And on the said date, this court had provided that in the event the petitioner remains absent or unrepresented on the next date of listing, or my adverse order. Is the petitioner remains unrepresented, our magistrate is dismissed from our prosecution. Next, the consequences of the opinion including this petition would follow. Next part, the registry shall send back the records. Return back the records of the revenue tribunal along with the copy of this order to be made a part of the court by the said revenue tribunal.
Item 8 for hearing.
Well, maybe matter taken up next week, my lord. In the meantime, I will allow to inspect the record also. No. We get a transfer to the transfer to the India. It definitely done, sir. Look at the day, my. It is very good to know.
You apparently don't find any error in the appreciation. All sets are represented on the prayer made by the learned counsel for the petitioner. The matter stands adjourned today. List again on. Give it date after a week.
Item 9.
Yes.
My lord, may have been shortened after 2 weeks, my lord. I have to obtain some instruction from the petitioner that I will not communicate him.
That is a very vague statement. What instruction you need at the time of hearing?
My prayer was there that his brother, at the time of filing the petition, his brother, elder brother was alive. Now, whether he was alive or not, I have no instruction, my lord.
Elder brother in what context?
Hello?
Elder brother in what context? I mean, the proceedings, petitioner's elder brother.
Elder brother.
That's not material. Whether his brother died or not, whether other family members died or not, that's not the concern of the court.
I'm trying to ask you is that there must be some reason why you're giving instruction.
Some additional document I have filed with this petition. Those documents which, in the event of remanding the matter back, he should be examined, my lord. No. Do you for a
That will never happen. Because we never appreciate a document which is not examined by the tribunal. That we will not do. You can be rest assured, whatever document you bring on record, we will not see. Apart from 8 documents, out of which exhibit A to G is in the tribunal's records, and the 8th document is the opinion itself.
Hello.
In your written statement, you don't disclose the name of your grandfather.
Hello.
You have not disclosed the names of any other family members you have.
Hello.
You have not disclosed your age when the you have not disclosed your age. That is the date of birth that you have not stated anywhere.
Well, it is wrong finding of the learned tribunal. I have disclosed my age at the time of filing the written statement in the verification and the submitting affidavit. Page number 32, madam.
Page number
32, verification, and 33, affidavit. Sorry, 34, affidavit.
okay.
He says that I am the son of Sadhu Mia. I have exhibited the voter list of 1966 and 1970 of my parents. My father's name is Shabinya and mother's name is Nasimun Nasa.
6 and 70.
Voter list 1966 is at page number 36, madam. Page number 38, the voter list of 1970, madam.
Which page is your written statement?
Written statement number
26.
26, madam.
Continue, we are listening.
Madam,
We are listening, we are hearing you. Please continue.
He's Meher Ali.
Meher Ali, my lord. My correct name is Meher Ali and recordically I am Meher Ali.
Sadhu Miah is his father.
Father, Sadhu Miah's father.
Yeah, is here in 1966, 70 or
1976 and 1970. My parents' names are there.
linkage.
Linkage document, my lord, the page number 40 on the Jamabandi copy.
Just tell us, in this, in this hotels of, between this 1970, after 1970 and before 1994, you don't have any voters list.
My lord,
93, that was for 23 years, there's no voter list.
at the time of filing the written statement as well as evidence, they could not produce, they could not collect. Subsequently, I have filed the voter list of 1985 and 89, my lord, along with the petition, my lord. Mother and elder brother are the voters of the year 1985 and the 1989 at the same village, my lord. Silosi, village Silosi.
Voter list of 1990,
1985 and 1989, my lord. Page number 71, my lord. Page number 72, the voters. Rustom Ali is my elder brother. And last one, Lesumon is my mother.
this voter is not an exhibited document.
Not yet,
No, shows the exhibited documents. Yes.
not executed.
85. 85 one is not.
85, not 85 and 89 were
But
not
66,
executed.
70 are executed.
My lord.
Jamabandi also executed.
Jamabandi executed, my lord.
Yes.
Jamabandi, page number. Jamabandi, page number 41. 41.
Page number
Jamabandi, page number 41.
51.
Vernacular is at page number 42.
Okay, from this Java, this exhibit number,
Exhibit, my lord. Exhibit E, my lord.
Exhibit number
E,
C,
E,
E.
my lord.
So which is the entry you want to rely on?
Jamabandi was also proved by the examining the last mandal, my lord. The certified copy.
Yes.
My lord, Jamabandi was discarded by the learned tribunal, saying that it is the entry of Jamabandi is concerned, it is a Jamabandi for surveyed villages, and said entries are prepared on fiscal inquiries. And the entry in the copy of Jamabandi has to be examined on the probative value of the contents of the documents which required corroborating with other documentary evidence. That is why, my lord, this Jamabandi was curtailed, discarded. My lord, one more thing, my lord. Please have a look at page number 68, my lord, the judgment order. Page number 68, my lord. 11 portion. Therein, a sentence is that on a cumulative analysis of the voter list as above, it is evident that Rustom Ali, the father of the opposite party, is traceable to the voter list of 1997 and not beyond. This is the wrong finding of the learned tribunal, my lord. My father's name is Sadhu Miya, and he is recordedly voters of the year 1966 and 1970. But here in this learned tribunal has stated that Rustom Ali is my father. This is the wrong finding, my lord. That about, my lord. My lord, that apart, the
Exhibit
petitioner,
number? The Jamabandi is exhibit number
exhibit E, my lord.
E.
My lord.
Petition was done. Pursuant to the date found.
as per order dated 18/11/78.
There is that finding which you are saying is incorrect.
My lord,
If he finding about the father's age. Age 16. Para, para.
Yes.
my lord, the petitioner's evidence, he was not cross-examined by the state, my lord. His evidence were not challenged by the state.
No questions by
No
tribunal,
question was put to him,
but tribunal also.
my lord. So his claim is that, my lord, his father's name is Sadhumiya, or the voter of the year 1966 and 70 at Philosophy. And linkage document is exhibit is Jamabandi copy. And he claimed that after 1994, after erosion of the said village, he shifted to village Mondia under same police station, my lord.
One Rustam Ali is also his brother.
Elder brother, my lord. Rostam Ali is his elder brother, but he was not examined due to his health issues, my lord.
The tribunal wrongly stated that Rustam Ali. is
Rostam Ali is the father. So this is the totally wrong finding, my lord. So, my lord, one thing is that in paragraph number 13, so far Jamabandi copy is concerned, the learned tribunal has stated copy failed to produce any other documentary evidence subsequent to such entries made on fiscal inquiries, and as such the entry in the copy of the Jamabandi is inadmissible in evidence in the absence of other substantial documentary evidence. My lord, in this, to that effect, my lord, I have, although not exhibited, but I have enclosed a copy, page number 77, my lord, 78. The said land were acquired by the government, and notice was also issued to the brothers, including the petitioner. Page number 78 is the vernacular. The notice was issued on 10/4/84 to take the compensation as granted by the government in respect of the said land money.
Okay.
My name is at serial number 6, Malot Meher Ali. So, so far the written statement is concerned, my lord, I am the illiterate person. I approved my time invitation, my lord. So it was the duty of the learned Angus council to elaborate everything. But that was not done. So the illiterate petitioner should not suffer, my lord.
Please continue.
So my humble prayer, my lord, one more opportunity may be given him uh, to examine the voter list of 1985 and 1989 of his mother and elder brother at village Silosi. And this document, that is the notice issued by the deputy commissioner.
We'll be taking up next week as a part and matter because you will have to rise at the routine.
My lord, maybe after 2 weeks, my lord, I will be out of station for treatment, my lord.
Your part is already over. No?
My lord, one more thing is that, my lord, I have to submit one more thing. There is no specific source. Either the allegation is that he has entered into Assam after 1971 or in between 71, 66, 71. There is no specific source in the notice. The grounds are also not mentioned of suspect. Grounds of suspect is also not mentioned in the notice.
The
Stream is not mentioned in the notice, my lord.
Subject on that. So if stream is not mentioned, the tribunal can examine both the streams. But it is always better to mention.
Can clarify.
Team will come after lordship, trial lordship.
Yeah.
Yes.
He'll be out of station for his treatment. We take it up the date after weeks.
You mentioned some judgment.
Yes, lordship, Rukia Begum Borgia is, so many elaborate discussion has been made, lordship, in this case. 2023 for GLC 1208.
Your name?
Zeus, Senate.
This is James. Same and for the school. Commissioner Secretary. The possibility of time the knowledge of state and department conflict would not be heard. List also. You get after 10 days. Department.
As a partner, lordship.
I think it's on Monday. Monday. Yes.
Thirty-first, will it be 31st August?
31st August.
Third time will not be available. There is a chance. Sure. Make it 31st.
My lord, on 31st August, I'll be at Baksha, my lord, in district court, my lord, Poxo case. কালি কালকে কালি রাখতে
Not keep it patterned. It will come, matters may have job today, make a change. Both sides are represented together, will be represented. The paucity of time matter could not be taken up today, list after 2 weeks. Due date after the. You can't keep it patterned because we may not be available, both of us.
Flexible.